Welcome, everyone, to this seminar at the International Institute of Social Studies. My name is Jeff Handmaker, and I'm an associate professor of legal sociology here at the ISS, which is part of Erasmus University, Rotterdam. I'm also an associate professor of law at the Witwatersrand School of Law in Johannesburg, South Africa, and am very grateful, pleased to be joined by the colleagues around this table, and particularly colleagues from the Boston University School of Law Human Rights Law Clinic. And we have 3 students from this law clinic who are going to be addressing you shortly with some opening words. Just bear with us for a moment. As with any event that we organize here, I basically just have 2 principles. The first principle, welcome, is that we be kind to each other. By being kind to each other means we don't use hate speech, and I think everyone knows what hate speech is. We're not going to use any of that. And the second part is that we don't have any ad hominem remarks, which means that you're attacking the person because of who they are, who you think they are, and not with engaging with what they said. And that's all, my friends. Those are only things which we need to have for a good discussion. So again, very much welcome to those in the room and to those online. We have quite a few people participating in this event, and this will be recorded, so we're going to be releasing it for later distribution. This is organized, just a sound check before I continue. Can everybody online hear okay? Yes? All right, thanks. Just need to give a heads up there, or just needed to have a heads up there. All right, so already a heads up for those online. If you would like to pose a question, you can do so through the Q&A feature or through the chat feature, and it will be moderated, and we'll make sure that your questions go to the panelists. But before we start this event, and I say a few opening words myself, I would like to welcome the students from the Boston University School of Law Human Rights Law Clinic. A warm welcome. Yeah. Yes, keep a distance, though, because super sensitive.
Good evening, everyone. Welcome, and thank you for joining us at today's seminar, Gaza at the ICC, Denial of Palestinians' Right to Return under International Criminal Law. So we're here to delve into the critical issue of the right of return as a fundamental human right and explore how its denial may fall under the jurisdiction of the International Criminal Court. And as we gather here today, the situation in Gaza continues to deteriorate at an alarming rate. Israel's relentless targeting of civilians and civilian infrastructure has escalated into a modern-day genocide. Palestinians are once again being uprooted, dispossessed, and forcibly displaced from their homes and their land, this time on an even larger scale than the Nakba. My name is Hannah, and I'm here with my fellow clinic members, Jackie and Ryan, as well as our professors, Ioana Kuzmova and Susan Akram, who have been instrumental in guiding us as we work on our submission. The International Human Rights Clinic, as Boston University School of Law, works on projects focused on advancing human rights, including current work regarding statelessness in the UAE and migrant disappearances on the US-Mexico border. And we're proud to say that our clinic has had a team dedicated to Palestinian advocacy for a number of years. And since September, we've had the privilege of building upon our clinic's collaboration with the International Center of Justice for Palestinians, an independent organization comprised of lawyers, politicians, and academics, all striving to support Palestinian rights and protecting these rights through the law. Together, we've been working on a submission under Article 15 of the Rome Statute to highlight the denial of the right to return as a crime against humanity, which my colleague Ryan will speak about now.
Hi, everybody. I'm Ryan. Thank you for coming. I'm going to briefly provide an overview of the submission that we've been working on. The communication begins by tracing the historical development of the right to return by looking at early ideas that people must be allowed to return to a homeland, and the Universal Declaration of Human Rights that states that people have a right to return to their country. We also examine how humanitarian law has engaged the concept, and specifically how Palestinian advocates have consistently called for and relied on a right to return since the 1940s. We also chart reaffirmations of the right in human rights law in texts like the International Covenant of Civil and Political Rights and the Convention on the Elimination of All Forms of Racial Discrimination. And finally, we look at international jurisprudence like the ICJ advisory opinions on the wall in Jerusalem and the 2024 ICJ advisory opinion, in addition to other relevant cases. Our professor and advisor and the director of the Boston University International Human Rights Clinic, Susan Akram, is going to talk a little bit more about our theories about the right to return. And she's also going to discuss the Israeli legal framework, which contributes to violations of the right. Next, we present our core legal arguments, which are that violations of the right to return are justiciable in 3 places in Article 7 of the Rome Statute as the crimes against humanity of persecution, forced transfer, and other inhumane acts. Each of these incorporates the right a little bit differently, and we attempt to show that actors who commit widespread and systematic violations of the right to return fit squarely within ICC jurisprudence. Our wonderful partner, Haydee Dijkstal of ICJP, is going to speak more about the legal theory. We then point to a selection of practices by Israeli agents which may be investigated as widespread and systematic violations of the right to return. We draw in state policies, laws, evidence of the destruction of homes and forced evacuations, the denial of judicial remedies, and evidence of intergenerational trauma and the protracted indignity of deprivation of access to a homeland. Ahmed Abofoul of Al-Haq is going to speak specifically about the present situation in Gaza as it relates to displacement and the right to return. And relatedly, as I said, Susan is going to talk about the Israeli legal framework. The goal is to show how violations of the right to return could be proven to be crimes against humanity, to urge the Office of the Prosecutor to consider all incoming evidence in the situation in the state of Palestine in the context of a right to return, and ultimately to persuade the prosecutor and the court that violating the right to return is justiciable under the Rome Statute. Our discussion today will be moderated by Dr. Jeff Handmaker, Associate Professor at the International Institute of Social Studies, who we've already heard from. And following the discussion, we invite you to join us for an informal conversation. We'll let you know where soon. I believe it's upstairs. And now we're going to go to our panel portion. Each of our speakers brings invaluable expertise to this very complex issue, and they ground our discussion in international law, human rights advocacy, and the lived experiences of Palestinian communities. Thank you.
Thank you very much, colleagues from the Boston University Human Rights Law Clinic. So I just want to say also a few more, show a few more slides to give also a bit more context to this discussion. So this is an issue in which I and Susan and Ahmed and Haydee have been involved in for quite some time. And more recently, of course, this conversation got an additional impulse because on the 21st of November, 2024, after hearings were concluded in the pretrial chamber of the International Criminal Court, the prosecutor of the International Criminal Court, Karim Khan, concluded that arrest warrants were to be issued and made those arrest warrants in relation to the situation in the state of Palestine. These comprise arrest warrants against Mohammed Diab Ibrahim al-Mazri, who is commander-in-chief of the military wing of the Islamic resistance movement, Hamas, known as the Al-Qassam Brigades, Benjamin Netanyahu, the Prime Minister of Israel. These are not those pictured on the screen in front of you, but I think you all know by now what these individuals look like. This is a prosecution team which issued the arrest warrants. And finally, Yoav Gallant, who's a former Israeli Minister of Defense. So the ICC has jurisdiction over several international crimes. It's often referred to as broadly as atrocity crimes, including war crimes such as deliberate killing and starvation of civilians without justification, and crimes against humanity, including apartheid and genocide, but also forced removals. And you're going to hear more about these crimes from our speakers. But this particular topic is of special relevance because of the historical connection to what we're dealing with in the present day. Most of those living in Gaza, prior also to October last year, when the latest war started, were already refugees from 1948 and from 1967 and various other wars in between. So again, a strong historical relevance to today's discussion. With the forced removal of Palestinians taking place during this war of attrition from 48 and all of these different wars, what happened then later, including in 2009, in refugee camps in Gaza, such as in Jabalia refugee camp in 2009, during so-called Israeli military operation Cast Lead, showed that refugee camps were considered a legitimate target by the Israeli military. And again, you're going to hear from our speakers how this comprises war crimes. More recently, again, particularly in the past year, Israel launched what it termed, and they have these very sort of Orwellian names, this particular operation called Shield and Arrow. There have again been massive forced removals. Virtually the entire population of Gaza has been forced to move on multiple occasions south, then north, and south again, and elsewhere in this tiny strip of land devoid of being bombed. However, as I've mentioned before and in the past year, this has not spared the lives of tens of thousands of Gazans, the largest group of whom are children between the ages of 5 and 8. Refugee camps have been the target of attacks, including this airstrike in November 2023, again in Jabalia refugee camp. So you've already had the speakers introduced by our colleagues from the Boston University, the Human Rights Law Clinic. So we're going to go, I think, straight to the first speaker. Is this a correct order, Haydee? So we're going to go first to Susan Akram. So I'll just give a brief introduction to Professor Akram, a little bit more of an elaborate introduction. You've already heard that she is clinical professor of law at Boston University and that she's director of the International Human Rights Clinic. She supervises students engaged in international advocacy in domestic, international, regional, and UN fora. And she's produced substantial research, which is focused on immigration, asylum, refugee, forced migration, and human and civil rights issues, with a particular interest initially in Latin America and more recently in the Middle East. Her distinguished research has been recognized with a Fulbright Senior Scholar Teaching and Research Award in 1999-2000, and she's lectured on Palestinian refugees, including at Oxford University's Forced Migration Studies program, as well as at various United Nations committees, including the High Commissioner for Refugees and the Relief and Works Agency for Palestine. The European Union represents representatives of European Canadian government ministries and parliaments, to name just a few. Professor Akram, you're again welcome back to the International Institute of Social Studies.
Thank you so much, Professor Handmaker, for that very generous introduction. And thank you all for coming to what I think is going to be a rather dense conversation. Can you hear me? And a special thanks to our wonderful BU students, Ryan and Hannah and Jackie, for all the work that they have put into this submission. So I'm going to focus on the law underlying the right of return for Palestinians and the Israeli legal mechanisms by which Palestinian refugees and displaced persons have been denied both their right to return and their right to repossession of their properties, that is, the place to which to return. Both the rights and the legal framework denying them relate to a range of systematic Israeli violations: forced expulsion, forcible population transfer, dispossession, wrongful property confiscation, and other inhumane acts. After I go through both of these topics, Haydee will then address how these violations relate to crimes under the Rome Statute. Israel's been engaged in forcibly displacing and dispossessing Palestinians since before 1948 and continuously to the present in a process the Badil Center for Palestinian Rights has long termed the ongoing Nakba. Palestinians were recognized under international law as nationals of Palestine from August of 1924 by virtue of the Lausanne Treaty, which passed on nationality to the indigenous people of the successor territories of the Ottoman Empire. Despite the recognition of Palestinian nationality to the overwhelming majority of Palestinian Arabs in Palestine, during the Mandate period, the British administration allowed Jews from around the world to acquire citizenship and settle in Palestine while restricting Palestinians who were outside Palestine from claiming their national rights. Following the UN proposal to partition Palestine and allocate 56% of the land to Jews who comprised no more than 1/3 of the population and owned at the time less than 7% of the land, Zionist militias began a systematic campaign of expulsion of Palestinians from their homes and lands. David Ben-Gurion himself authorized Plan Dalet, or Plan D, in March of 1948, which had been prepared by the Haganah High Command for the Zionist militias to carry out systematic expulsion policies. Plan D instructed the militias to surround Arab villages, and if there was any resistance, to destroy the villages, expel the inhabitants from Palestine, and prevent their return. This was soon followed by the new Israeli cabinet in May with the establishment of a transfer committee to expel further Arab communities and a committee for abandoned Arab property to take over Palestinian property left behind. In early June of 1948, the transfer committee received approval from Ben-Gurion for a plan entitled Retroactive Transfer, a Scheme for the Solution of the Arab Question in the State of Israel, to prevent Palestinians from returning, to destroy as many remaining Palestinian villages as possible, to prevent Palestinians from cultivating their lands, to enact legislation to bar the return of the refugees, and to settle Jews in their places. These objectives were carried out. And in the aftermath of the war and these decisions, about 350 Palestinian towns and villages were completely or partially destroyed and depopulated. Between 1947 to 1949, 750,000 Palestinians, approximately 60% of the population, were forcibly displaced due to over 70 Israeli massacres, destruction of homes and villages, rapes, and other strategies designed to sow fear and panic. Once the provisional policies were in place to prevent return of the refugees, Israel rapidly passed a series of laws to denationalize Palestinians, confiscate their properties, permanently bar their return, and dispossess them of their lands. As for the occupied territories, by the time the 1967 war came to an end, Israel had occupied the West Bank, Gaza, and East Jerusalem, and more than 400,000 Palestinians, or 1/3 of the population, were forcibly displaced both within and outside historic Palestine. Israel then expropriated what is now the majority of Palestinian land in the occupied territory through similar regulations as within Israel, but through military orders. To deny Palestinian return and ensure Jewish settlement in their places, Israel passed the 1950 Law of Return that entitles all Jews from anywhere in the world to enter Israel as nationals of the state, while it excludes non-Jews from nationality rights. In 1952, Israel passed its citizenship law, which denationalized Palestinians, explicitly denationalized Palestinians, and created a two-tiered system: nationality for Jews with superior rights, and citizenship, but not nationality, for others, including Palestinian Arabs in Israel, with second-tier status affecting rights to property, housing, resources, benefits, and return. The Israeli government set to work to legalize Palestinian dispossession through the use of a whole series of legal mechanisms. I'll just mention a few. First were the emergency regulations, then the absentee property law of 1950, the settlement of title land registration process, closed areas, security zones, public purpose ordinance, cultivation of wasteland, and on and on. Israeli authorities have used a twofold strategy to complete control of Palestinian land and prevent return by the rightful owners. First, after clearing the land of its Palestinian residents by military means, legal tools were put in place to confiscate the land. Second, using emergency regulations and other policies, Palestinian villages and properties were declared absentee lands, transferred to Jewish hands, and prohibited from being alienated to non-Jews. Absentee property regulations were put in place as emergency laws as early as in early 1948, and later passed by the Knesset as the Absentee Property Law of 1950 and its amendment. This is such an important law that I want to spend a minute telling you about the most fundamental aspects of it. The Absentee Property Law provides that any person leaving his residence for any length of time after November 29, 1947, for an area held by enemy forces or armies that fought to prevent the establishment of the state of Israel, are deemed absentee. Once declared absentee, their property is subject to confiscation by the Israeli custodian of absentee property. No restitution is permitted once the custodian transfers this property in good faith, so-called good faith. The lands are turned over to the Israeli custodian for absentees' property and can only be sold to government authorities and the World Zionist Organization. Absentee lands taken from Palestinians become part of what's called the Israel Lands Bank, which can only be used in perpetuity by Jews. It's been extremely rare for property confiscated by the custodian to be returned to any Palestinian wrongfully found to be absentee. And we know this through the hundreds and hundreds of cases that have gone through the Israeli court system. And today, what was 90% of Palestinian-owned land through these mechanisms has been converted to the property in Israel lands, holding 90% of the total lands in Israel. There are two other categories of dispossession laws: the settlement of title and state property law, and the public purpose ordinance, that have been also used as major mechanisms to transfer title from Palestinian ownership into Israeli lands. But through these nationality, citizenship, mass and ongoing expulsions, and forcible transfer, the law of return and property takings, Israel has ensured that no Palestinian can exercise his or her right of return, not as an individual and not collectively. And just a couple examples of villages whose inhabitants have fought for decades to return to their homes through the Israeli court system are the Kafr Bir'im, Ikrit, and Araba Subih Bedouin tribe communities. Using emergency regulations, Israel expelled the Palestinian villagers of Ikrit and Kafr Bir'im from their properties, closed off their village and the surrounding areas for so-called security reasons, declared the property abandoned or uncultivated, and permitted the state to confiscate it. The series of court cases brought by the villagers of Ikrit and Kafr Bir'im to regain their land show the extreme measures that the government and the Israeli Supreme Court have gone to thwart legal challenges to expropriations based on security concerns that are not valid. These emergency regulations have never been used to evacuate Jewish communities and expropriate their property. Kafr Bir'im was a Palestinian Christian village established over 400 years ago with an ancient history, identity, and cultural heritage. Before 1948, there were over 1,000 people living in Kafr Bir'im. The inhabitants hold the deeds to Kafr Bir'im property going back to the time of the Ottomans. On October 29, 1948, after hostilities had ceased, the IDF occupied the village, ordering all the villagers to assemble in the community church and surrender their weapons. The villagers did not resist. On November 13th, the IDF ordered all the residents to move across the Lebanese border. Some obeyed, but others refused and stayed in their olive orchards to wait until the IDF would allow their return. 7 children died there that winter, and the villagers kept trying to return home. By November 20th, all the remaining residents were forced to relocate to the nearby village of Al-Jish, whose inhabitants had all become refugees by that time. Between 1949 and 1950, the villagers continued to try to get permission to use their agricultural land, use the church land, return to their homes. They petitioned twice to the Israeli Supreme Court and many times to the military authorities. Surprisingly, the Israeli Supreme Court ordered the government to allow them to return, and in response, the IDF declared the entire village closed military area and bombed and dynamited all the homes. A similar story is that of the Bedouin village tribe Arab as-Subiyah and the village of Shibli. While their rights to hold and use their land would have been protected under the Ottoman Land Code and the British Mandate laws, the Israeli government forced the entire Bedouin tribe to evacuate, leaving them with a small strip of land today known as the village of Shibli. Some of the property was confiscated under the absentees property law, and in the 1980s, the government of Israel instituted Jewish land settlement operations, including the area known today as the village of Shibli, knowing full well that most Bedouins had never registered individual title to the property they had held and cultivated, but was recognized as communal property in Ottoman times. So the land belonging to this Bedouin community continues to be confiscated today. Like the Ikrit and Bir'im villagers, Arab as-Subiyah tribe members have been prevented from returning to any of their lands or properties, despite multiple cases through the Israeli court system. But what right do internally and externally displaced Palestinians have to return? And is Israel under any obligation to implement it? Let me briefly touch on the sources of the right of return. The legal sources of refugee right of return are found in 3 main bodies of law: the law of nationality, state succession, human rights law, and humanitarian law. And in each of these bodies, the right of return is found both as a rule of customary international law and codified in international treaties. The state responsible for implementing right of return in the Palestinian refugee case is, of course, Israel, the state responsible for creating the refugees, and which has ratified numerous treaties that bind it to recognize and implement such a right. Very briefly, the law of nationality, state succession, imposes 3 obligations on newly created states. First, that a successor state must grant all persons found on the territory the nationality of the new state. Second, that a successor state is forbidden to arbitrarily denationalize or expel persons found on the territory. Particularly prohibited is expulsion or denationalization on the basis of race, religion, ethnic or national origin. And third, the residents of the territory expelled during conflict are absolutely entitled to return to their places of habitual residence. These principles, already binding on Israel by customary law in 1948, are further strengthened by their inclusion in human rights and humanitarian law treaties, as I said, which Israel has signed and ratified. Israel is a party to the Civil and Political Rights Convention, the Convention on the Elimination of Racial Discrimination, the Convention on Economic, Social, and Cultural Rights, which all prohibit denationalization, expulsion, or denial of right of return on the basis of race, religion, national, or ethnic origin. The Civil and Political Rights Treaty is considered the main source of the right to return to one's country in its Article 12.4. Under humanitarian law, of course, the law applicable to armed conflict, there are clear prohibitions on belligerent occupation, on forcible expulsions, on states preventing persons from returning to their homes following hostilities. And these rules are codified in the Hague Regulations and the Fourth Geneva Convention, to which Israel is either a party or acknowledges is binding on it. Right of return is an even stronger principle in the branch of human rights law applicable to refugees. Widespread state practice, particularly in the last 50 years, has firmly embedded the right of return as a core obligation on states. State practice includes incorporation of right of return in peace agreements, such as the Comprehensive Plan of Action of Indochina, Serefka in Central America, Cambodia, Mozambique, Rwanda, Dayton, the Dayton Accords for Bosnia and Herzegovina. State practice includes its widespread implementation of right of return and is the only one of the three durable solutions that is both a right and a binding obligation on the state of origin. An additional legal foundation supports the right of return in the Palestinian case, the large body of UN resolutions that refer to Palestinian rights of return. These refer to the right of return as an unconditional right, inalienable right, and an imprescriptible right. They, of course, reaffirm the basic formula for the durable solution required in the Palestinian refugee case, found in the very first resolution requiring that it be implemented for Palestinians, General Assembly Resolution 194 in its paragraph 3. One can say that the right of return, based as it is on numerous provisions in customary and treaty law, and so widely accepted and implemented by states, is one of the strongest legal principles in existence. Hence, violation of the right of return can constitute war crimes under humanitarian law, violation of state responsibility, and violation of human rights law, in particular refugee law. It's important to note that since Israel's denationalization of Palestinians under its 1952 law violates the law of state succession, violated the law of state succession at the time, among other obligations, Palestinian right of return is based primarily on their national rights, their nationality rights to return to their place of origin. Despite strong legal rights of refugees to return, restitution, and compensation, repeatedly reaffirmed throughout the UN machinery implemented around the globe, Palestinians have not been able to access remedies as victims of the denial of right of return and the underlying violations it involves. This illustrates the importance of our submission to the International Criminal Court to add the denial of the right of return to the court's charges of crimes against humanity. And Haydee will now address that.
Okay. Well, I want to echo thanks to everyone. Oh, yep, of course.
Okay, just wanted to say a few words of introduction to our learned counsel from 33 Bedford Row. Haydee Dijkstal is a chief external counsel at the International Center of Justice for Palestinians and a practicing barrister at 33 Bedford Row Chambers in London. Ms. Dijkstal, who originally hails from the Netherlands, practices in the field of international criminal law and international human rights law, as well as general crime. She is also a US attorney with over a decade of experience. Dijkstal is currently head of the International Law Division at 33 Bedford Road. Thank you very much.
Thank you very much for the introduction. And again, thank you for everyone who's joining here in the room and also online as well. What we've covered so far is the body of law that's very developed and sets out this fundamental right. But what I want to talk about, and I think what our submission to the ICC really addresses, is how that body of law translates into a remedy and what type of remedies are available. And the one that I'm going to talk about in particular is whether there's a remedy under international criminal law for acts which violate this fundamental right to return. International, I think it's worth explaining or just making a note about the differences between a remedy under international human rights law, for example, and international criminal law. So when we're looking at violations of a right to human rights, what we're often doing is focusing on the harm to the victims and the obligations of the state, and whether or not there can be a finding that that right has been violated, and any kind of recommendations to the state to remedy that violation. When we're looking at international criminal law, the remedy that we're looking at is individual criminal responsibility. Is there a person who's responsible criminally for the act that's happened, and can they go through a trial and have their guilt or innocence determined on that crime? So the question that we've been asking is whether the violation of the right to return can fall under international criminal law, and whether individuals can be held individually criminally responsible for preventing individuals or groups from being able to return home. So when we look at, we've been looking at the International Criminal Court, which is the Rome Statute is its foundation. The crimes that the court has within its jurisdiction are enumerated in the Rome Statute. And when you look at the Rome Statute, there isn't a crime that specifically sets out a violation, a crime for an act which violates an individual or a group's right to return. So, on its face, it would look like that's a gap in recourse or a gap in the remedy, where individuals cannot find accountability to have somebody held accountable before the International Criminal Court. But what we are looking at is an examination of whether those underlying acts, so the actions that are taken by an individual to deny that right, whether there are existing crimes within the Rome Statute, when you look at that underlying act, if it can fit within existing crimes there, and those crimes can be utilized. So looking at, okay, if there isn't a crime of denying the right to return, what crimes are in the Rome Statute that can be utilized and can be used when you just break it right down to what the underlying act is that we're talking about. So let me go through some of the crimes that we've identified that we think or propose and suggest that the prosecution of the ICC could use and could, when they're receiving evidence that shows that there's been a violation of that right to return, how can they view that evidence through a lens of the crimes that they have and utilize those crimes in order to make sure that there is a remedy under international criminal law as well. So let me just start off with the crime against humanity of deportation or forcible transfer. So just to explain a little bit about what that crime is, it's when, the way that it's defined in the Rome Statute is when a perpetrator forcibly transfers without grounds permitted under international law one or more persons to another state or another location by expulsion or by other coercive acts, which are any kind of act which essentially forces that person to flee for their lives. If not for those acts, they're just forced to leave. So the crime refers to forcible removal of one or more persons to another location. And I think we most often contemplate this in the context of a group being forced either physically or as a result of these coercive acts to move to another place. So the question is whether this crime can apply to an act which is often viewed as coming after the group leaves and is moved to another place. So the act being not being able to return, but could we also look at it as and view it as a continuation of a crime? So looking at the historical context behind that act as well. Whether that crime is being continued, they're forced to leave, but then it's continued and completed by not being able to return. Just a note on that historical context that I think will be really key to analyzing this crime. The ICC, it has jurisdiction. Jurisdiction is not only territorial, but it's also time-based as well, temporal jurisdiction. So the ICC can only look at crimes, can only prosecute crimes that happen from 2014 onwards. But what the case law, what the judges have determined at the court is that while they might not be able to prosecute, to say, an act that happens before 2014, they can't say, well, one of those acts, we can prosecute that and charge somebody for it. But they have said that acts that are outside of the jurisdiction of the court can be looked at to provide context, to provide a greater understanding of the crimes that are within the jurisdiction of the court. So it's not that anything that happened before the temporal jurisdiction of the court just can't be looked at all. It's important evidence that gives context to the crimes that have happened within, the crimes that the prosecution can look at and can potentially charge as well. So what we're looking at is whether this could constitute a crime, whether somebody's forcibly transferred or deported, and looking at examples that are more recent, whether it's evacuation orders in northern Gaza, which have caused people to move and move again and continue to move, and what's the end result of that, or what's the motivation or context behind it. But even looking at acts that destroy civilian property as well. Including homes or other infrastructure that makes it impossible for a population to be able to return. So that's one of the crimes against humanity that we're looking at, that we're saying, depending on the facts, this could be a crime that could be utilized, even though there isn't a crime of the right to return. Another one is the crime against humanity of persecution. So in the Rome Statute, the crime against humanity of persecution, one of the key elements to that crime is that one or more person has had their fundamental human rights violated. So, as we talked about before, there's already a body of law under international human rights law, multiple human rights conventions and human rights instrument that codify and make that right very firm under international law. So showing that a group or an individual or more than one person has had that right violated. Of course, with a crime against humanity, we also have to show the widespread or systematic nature of it as well, the more contextual elements. But that right can go directly to the crime against humanity of persecution. Of course, the additional element to that crime is that it was violated and the targeting was based on political, racial, national, ethnic, cultural, religious, or gender grounds as well, which we think would fall firmly within a lot of the evidence that you can see of instances where individuals and groups' right to return is being violated. The next one that we're looking at is the crime against humanity of what's called other inhumane acts, which is a bit of an interesting crime in the Rome Statute. I think at first glance, it looks like a bit of a catch-all crime, but I think the wording of it tries very hard not to be that. What it says is that when a perpetrator inflicts great suffering and serious injury or body or mental or physical harm to an individual or a group, that this is an inhumane act. But what it then tacks on is that the way that they're looking at acts that are similar to other crimes against humanity. So they're trying to focus it on, is this act that caused great suffering similar to another crime against humanity? So it could be, is it similar to deportation and forcible transfer, or is it similar to persecution and caused that great harm? So that's how that crime is defined. And what's interesting here is the pretrial chamber in another situation before the ICC weighed in on this. And this is in the situation that has to do with the Rohingya Muslim population that was forcibly, I suppose, deported from Myanmar to Bangladesh. And there was a jurisdictional decision that happened in 2018 in which the court found that they had, so Myanmar is not a member of the Rome Statute, Bangladesh is, and individuals were forced from Myanmar into Bangladesh. And so there was a question of, well, did this happen in the territory of a Rome Statute country, so can it fall within the jurisdiction of the court? And the court said yes. As long as one element of the crime happened in a Rome Statute country, then it does fall within the jurisdiction of the court. So this is a small jurisdictional window. It doesn't apply to every crime. It's really focusing on crimes that have to do with movement. So deportation falls squarely within that. So the fact that they were pushed from Myanmar into Bangladesh, that crime was completed when that population was forced into Bangladesh and into the territory of a Rome Statute country. But what they looked at was, so the jurisdictional window there fell for deportation and forcible transfer, for persecution, but also for other inhumane acts. And the way that they brought that in was by looking at the great suffering and mental and physical harm that was caused by that deportation. And what was interesting is it said, preventing a person from returning to his or her own home causes great suffering or serious injury to mental health. In this manner, the anguish of persons uprooted from their own homes and forced to leave their country is deepened. It renders the victim's future even more uncertain, and it compels them to continue living in deplorable conditions. So bringing in that great suffering from the fact that somebody is not only forced to another place, but then prevented from returning home as well. Those were the core three crimes against humanity that we were looking at. But I do also think that the crime against humanity of apartheid could potentially be examined and utilized depending on the facts that are before the prosecution as well. Apartheid being defined in the Rome Statute is as an act where the perpetrator committed an inhumane act against one or more persons. And then the key part being that the conduct was committed in the context of an institutionalized regime of systematic oppression and domination over one racial group. Now, switching gears away from international criminal law and looking at public international law and international conventions, there is the International Convention on the Suppression and Punishment of the Crime of Apartheid. And here it does talk about the fact that the term of a crime of apartheid shall include certain inhumane acts, and then they list and give examples of that as well. And that can include the right to leave and return a country, so that being one of the inhumane acts that might contribute to a situation that can be defined as apartheid as well. So, of course, what we're suggesting is that these four crimes are potentially crimes already there, ready for the prosecution to use. The facts will always be different. So depending on what's the prosecution finds in its investigations or what evidence is given to the prosecution, it might fall under one of these crimes or not. But what we're asking is that the prosecution view the violations to the right to return, focus on them, and view them through the crimes that are already there, as well as victims groups as well. So this is not just the prosecution we're suggesting this to, but also to any groups that are working with victims, that are doing advocacy, that are talking to the prosecution or submitting evidence as well, that they view this evidence within the context or through the lens of the right to return and what crimes could be used at the ICC as well. So let me pause there, and happy to answer questions later.
Thank you very much, Ms. Dijkstal. These two talks have really set this up very importantly, looking at the historical context, the continuity of these crimes, the really complex nature of these crimes, and to our next speaker. And this speaker is Ahmed Abofoul. Ahmed Abofoul is a colleague of the International Institute of Social Studies. He worked here for a couple of years. Presently, and actually for some time, he has been an international lawyer and legal advisor, originally from Gaza. He's currently working, as he has been for some years, as legal research and advocacy officer at Al-Haq Europe, and Al-Haq based in Ramallah, the oldest Palestinian human rights organization. As I said, he was previously a member of faculty here as a visiting research fellow at our institute from 2022 until 2024, during which he was an active member of our research group and within the Legal Mobilization Platform. He has published with Opinio Juris and elsewhere on international criminal law, including ecological crimes, and on international human rights law and international law generally. Ahmed Abofoul, again, to you also, welcome back to the International Institute of Social Studies. We're very glad to have you here.
Thank you. Thank you, Jeff, for the kind introduction. It's good to be back. And I have to say, it's quite difficult to speak after Susan and Haydee. They didn't leave me much to say, but I'll try, and I'll try to be brief. Absolutely, this is an important topic, and I was asked to talk about the current situation in Palestine, so I would stick to what I was asked to talk about, but at the end of my intervention, maybe I'll comment briefly on what was mentioned. I think one of the most important things that were said today is the importance of keeping in mind the context in which crimes take place. International criminal law cannot be so rigid to focus on criminal conduct isolated from any context. And as you referred to, the jurisprudence of the court actually confirms the importance of context. And I will start with the current situation in Gaza and the context which a lot of governments wish to ignore and wish to behave or believe that what happened on October 7th happened in a vacuum. But as the United Nations Secretary General noted at the early days, that this did not happen in a vacuum. Indeed, this was the result of over 76 years of Zionist settler colonialism and apartheid imposed on the Palestinian people as a whole. This was also the result of over 56 years of Israel's longest in modern history, belligerent, illegal occupation of the Palestinian territory, including East Jerusalem. And this is, of course, the result of Israel's over 17-year-long medieval suffocating military blockade on the Gaza Strip, where 2.3 million Palestinians, 75% of whom are refugees, were ethnically cleansed from their homes and villages in 1948, live in around 365 square meters. This is one of the most densely populated areas in the world. And the reason to that is the fact that Zionist militias in 1948 ethnically cleansed Palestinians and pushed them to a strip of land and denied them the right to return. To understand how difficult the situation was in Gaza already before Israel's assault, just imagine that in 2012, the UN published a report concluding and expecting that Gaza will be an unlivable place by 2020. This is before all of this happened. Already expected Gaza will be unlivable by 2020. Now we're 4 years past that, with a relentless and indiscriminate bombardment of the Gaza Strip, targeting civilians, destroying infrastructure, Already in the first 3 weeks alone, Israel bombed Gaza with the equivalent of 2 nuclear bombs like those thrown on Hiroshima and Nagasaki in the first 3 weeks alone. So I think this sums up the situation. I'm sure a lot of you are aware of the current situation, the catastrophic circumstances in Gaza, unfortunately with complete indifference and disregard of human life and Palestinian suffering from the war, ugly complicity of states that have always preached about international law and presented themselves as the guardians of human rights. We live in a moment, and I think I mentioned this from this very podium, we live in a moment where it's clear that mask is off because of Gaza. And I think one day we will wake up to realize that the Palestinians in Gaza were fighting for all of us. It took a genocide, but I think it's becoming clear that we don't live in a post-colonial world, but we do live in a neo-colonial world, where some states still believe of themselves as masters and other parts of the world as slaves or worthless people who can be killed, children of the dark, as some Israelis have called them. The current situation is indeed the result of decades-long systematic and prevailing impunity of Israeli officials and military personnel. And they enjoyed that because of the support of Western states in particular. Israel's settler colonialism and apartheid regime is premised on a promise of impunity to its soldiers to commit these crimes, to dehumanize and oppress the Palestinians. And that's why it's been clear for Palestinian organizations for decades, because of that promise of impunity, Israel is not genuine, nor is it willing to provide any meaningful accountability for its officials and soldiers' crimes. And I think here comes the importance of international criminal law. And as some would want to put it, the promise of Nuremberg. We thought after 2 horrific world wars, we have agreed that those who commit crimes must be held accountable. And such atrocity crimes must not go unpunished. But what we're witnessing today, especially with the latest statements from certain countries after the arrest warrants in Palestine, including France, Germany, the Netherlands here, country I'm national of and ashamed of its positions, they seem to be willing to distort international criminal law in the service of an apartheid regime. They're willing to destroy this body of law, which is the common heritage of all human beings. It's not the property of the West. And here, if you allow me just to say a few words, it seems for me, because of that experience, it's often referenced that Nuremberg was the origin of international rules-based order and the origins of international criminal law as we know it, as a matter of fact, the Nuremberg trials and the Tokyo trials. But a lot of people in a way omit the fact that those, although were a great contribution to international criminal law, they were also trials of the victorious. None of the crimes committed by the Allies were actually addressed. None of the perpetrators of the Allies were held accountable. And the fact that none was held accountable, it did not make those crimes less of a crime. The carpet bombardment of Dresden was a crime. The fact that the Allies did it, it didn't make it less of a crime. The Hiroshima and Nagasaki nuclear bombardment was a horrific crime. As a matter of fact, it was an unnecessary one even. It was just a mere show of muscle by the US telling the world that this is the message, this is the power we have, and we're the country that will control the world. And we still see the repercussions of this until this very moment, where Europe cannot break out from US hegemony and being able to destroy and distort international law in service of US imperialism and Israeli colonialism. And I think this has created in the Western mentality a deep belief that this body of law is their property, is their own, where they can use to prosecute others, but they cannot envisage a scenario in which they or their allies will be held accountable. And that's why you see the reaction today, that they're willing to destroy a project like the ICC, which again, it's an important one for all humanity in the service of an apartheid regime. So I think that the topic today cannot be more timely. And the importance of conducting investigations at the ICC with the right of return in mind, in my view, goes back to the fact that it is crucial that we characterize the situation as it really is. That is a situation of settler colonialism, to address the root causes of these situations. And once we do that, things start to make sense. And settler colonial regimes throughout history were premised on the idea of the elimination of the native through genocide, which we're seeing now, or if that wouldn't work, the attempt to colonize the land without the people, so trying to push them somewhere else, wanting the land and the resources without the people. And here the right to return kicks in, because once you understand this is a situation of settler colonialism, regardless of any justification that regime, Israel here, would say or give for their actions, if you look deeper, you will see that the purpose is to get rid of the people, to get them out. And you see it now in Gaza. What is the objective of Israel? But nothing that Israel does now can be justified under any justification. The clear intent is to get rid of the people, to push them to Sinai. And this is not analysis or speculation. As a matter of fact, all we need to know is to listen to what Israeli politicians are saying all the time on media. So our European colleagues are not required to do a lot of mental efforts, maybe just to employ their hearing skills and listen to what the Israelis are saying, like, don't listen to us. And I think one of the most important things when it comes to settler colonialism, that even when it tries to push part of the people out, like 1948, for those who remain, the native becomes an obstacle for the colonizer. And that is something Fanon spoke about a lot in his amazing work. And that's why you have the imposition of an apartheid regime, where one group will have all the rights, the other will not have rights, essentially to create a cohesive environment for the indigenous, that they have no choice but to leave for their lives or for a better future for themselves and their kids. And that is what's going on also in Gaza, but in the West Bank and East Jerusalem for decades. But in Gaza, as clear as it could get, the purpose is to make Gaza uninhabitable again, uninhabitable completely, like again, to not allow the Palestinians to ever return to their homes. That's why Israel is not only targeting Palestinian homes. There was no school that was not targeted, no hospital that was not targeted, no library, ministry, university, you name it. And there can be no military advantage or conduct of hostility logic behind that destruction. And if you keep looking, and let's analyze proportionality, distinction, and get in the technicality of IHL, you'll never reach any point if you don't have, as you called it, the lens of the right to return. But I would even use the word to have settler colonialism in the back of mind of an investigator. because this will make it clear what the purpose is. And the question is, does the International Criminal Court have this decolonial thinking in their minds when they're investigating these crimes? And of course, we're not naive. We understand that criminal investigations are complex, especially in situations where you don't have access, and sometimes not all crimes can be taken to court for different reasons, including evidence, litigation considerations, or otherwise. But regardless of all of these considerations, which we believe the International Criminal Court should take them in consideration, it must be done with the understanding that this is happening in the context of Settler-colonialism, to make sense of why things happen, and not to buy in Israeli propaganda if there is anyone who still believes in it. I think it's becoming very clear what we knew for long, that the Zionists are pathologically lying, and Israel has been doing that, and I think it couldn't be more obvious now. So I think this submission you spoke about is a really interesting one. And I think it's already applicable to the situation in Gaza, the displacement of Palestinians in Gaza, and the denial of their right to return to their homes. Perhaps this is the most clear part of it when we talk about temporary jurisdiction before June 2014 and after June 2014. And it's important to note that the court had already issued arrest warrants for the crime of persecution based on the denial to the right to life, right to food. So practically it is possible, or the court have to decide if the prosecution presents the case with the Settler-colonial framework, that this is also denial to the right to return, not only the right to life and the right to food. So I hope this sums up what I meant by this long introduction. Thank you very much, and I'm sorry if I took long, and I look forward to hearing the questions. Thank you, appreciate it.
Thank you very much, Ahmed. That really presents a very powerful picture of what we're dealing with, and what you in particular have been dealing with, and the students at the Boston University Human Rights Law Clinic are dealing with in the submission that they've done together with their colleagues at this International Center for Palestinian Justice. Excuse me for forgetting the name. Okay, we have time for questions, and as I said at the start, those of you who are online can pose your questions in the chat. Those of you here in the room can just raise your hand and we will come to you. Really, it's an opportunity to ask questions of three of the foremost scholars in this area. Please, would anyone like to pose a question? I do have a question. I will just walk to you. Yeah.
Okay, I'll hold it. Okay. So, what I was wondering kind of throughout the whole talk is most Western states, they champion a two-state solution, which would basically mean that some form of an Israeli apartheid state would be maintained, albeit in a smaller area. So how could this be compatible with the right to return, as it would basically require a large portion of the displaced Palestinians to give up their right to return to their homeland? So would that basically not be a kind of a no-go when it comes to the right of return?
Thank you very much. Really good question. Again, we hear a lot about the two-state solution. Should we take some more questions if there's anybody else? Anybody else? Yeah? Should we take that one first, and then you can let that percolate a bit longer.
Okay.
Thanks.
So I can start. I have always approached this question with saying that justice has to come first before one looks at the territorial outcome. And the way right of return has now been narrowed into the only option as a two-state solution, so-called, is from a refugee law perspective, for those people who would be sent to, say, the West Bank or Gaza, for whom that was not their place of origin, that's not right of return, it's resettlement. And therefore, that would not be justice. But having said that, the right of return could be compatible with two states, with a cooperation between two entities, but where equal rights have to be preserved on both sides. And interestingly enough, if you go back, everyone seems to accept that Resolution 181 authorized two ethno-national states. If you read Resolution 181, that's not what it did. It talks about the two Palestinian people, the two peoples of Palestine, and a Jewish territory and an Arab territory. But the precondition for those two states or territories to come about was that the UN was supposed to supervise for a period of 1 year the drafting of constitutions on each side that would guarantee equal rights for the people on both sides. And people could choose in which state they wish to live. All of that was violated by the establishment of the Israeli state. So if we go back to 181, we have a sort of two nationals in the same territory with equal rights, ability to move where they wish, and the right to return as fundamental. So that's my initial answer.
Thank you. Thank you for this question. Maybe at the outset, I should say the position of the organization I represent. So Al-Haq does not take positions on political solutions. We believe this is for the people to decide through their representatives, through a political process, democratic process, and elections, something that Israel has been preventing for decades. And its champions who believe in two-state solutions and democracy have been doing absolutely nothing to allow elections. So we believe it's for the people to decide, but what we advocate for, that any political solution the people decide must be in compliance with international law and human rights. No political solution should be at the expense of human rights. And regardless of that solution, people need to achieve their human rights. So whether two-state solutions, 3 states, no states, whether you call it Palestine or you call it Republic of the Watermelon, for me, I couldn't care less. I was ethnically cleansed from my homes and villages. I'm a 3rd-generation refugee. I have connection to my hometown, and I want that to return. Even if I have 1 centimeter that I will stand in for the rest of my life, I want it. And there's no force on earth can tell me I do not have this right. But on the two-state solution, since you mentioned it, I have to say, it's important to understand that those who champion the two-state solution, in my view, I'm here referring especially to Europe and the US, Canada, the Western states, basically, I don't believe they've ever been genuine about it. For the simple reason, if you genuinely believe in two-states solution, why do you only recognize one? Right? If you genuinely believe of two-state solution, why do you allow one to perpetrate the longest occupation in modern history, give it all the weapons it needs to torn children into pieces, which is live streamed in our cell phones every day, and ensure those perpetrators impunity, willing to distort international law and destroy even international institutions to ensure their impunity, and for the other, you allow to be killed every day. This to me does not sound really a belief of two-state solution. It seems to me it's just a hypocritical mantra that certain states are using to hide behind. And I don't say this lightly. And here I speak in my personal capacity. I do not believe those who championed for the two-state solution in its current form. Before that point, maybe just to point something, even with the framework of two-state solution and the so-called Oslo Accords, it's important to note that the agreement between Israel and Palestine never actually, and the PLO never actually entailed that refugees will be resettled to the West Bank or Gaza. Refugees was one of the 5 issues that were left aside to the final settlements. So there was never a consent from Palestinians that refugees somehow give the right to return. It's also important to realize right to return is an individual right. It's a personal right. It can't be part of a political process, but it's for every person to decide, do they want to return or they accept the proper compensation or not, and return again, not to any part of the country, to their homes and villages, the country that they have connection to. But back to that point on two-state solution, I don't believe it was ever intended for the benefit of the Palestinians or the Israelis for that matter. And that's my personal view. I believe Western states have always supported this mantra of two-state solution to hide behind it. Then they can say they're two equal sides, they're disagreeing. Let's sit and talk indefinitely, negotiate. Maybe you find a solution, and then it's easier for them that publicly it's not clear the ugly support for an apartheid regime. Now it's becoming ugly since becoming really clear how ugly it is in the past year. But I believe this has been the objective all along. If those states really believe in two-state solution, they need to recognize both states and start applying international law principally, hold those responsible for crimes accountable, impose sanctions on those who commit crimes, stop sending arms to those who kill children and commit crimes. None of that is taking place. So I don't take it seriously, and I don't believe any of the states that repeat this mantra really mean it or genuine about it.
Thank you very much. Again, we're open to questions from the hall. Just raise your hand and I will come to you. So I have a question. It seemed to be also in earlier discussions around this that there's actually kind of a bifurcated understanding of what the right to return means. On the one hand, there was this Ahmed Abofoul has eloquently, and the rest of you have also eloquently defined an individual right, something which is inalienable and extends obviously without any time limitations. But there's also a collective right to return as well. Susan, can you maybe explain a little bit about what this entails? And is there a tension between the collective right and the individual right? Are they compatible with each other?
So I can start with the point that I was making about Palestinian nationality. And what's interesting about Resolution 194 and the United Nations Conciliation Commission for Palestine that was created under Resolution 194 is that the definition of Palestine refugee is not a refugee definition for purposes of the UN entity that was supposed to implement the durable solution that is embodied in paragraph 11 of Resolution 194. It is a nationality definition. And paragraph 11 makes it clear that it is all of those nationals so defined, that is everyone whose nationality relates to the 1924 Lausanne Treaty and their descendants, who are entitled to return, restitution, and compensation, the durable solution in paragraph 11. And that the international community's obligation towards them as a national group, a national population, does not cease until that durable solution is achieved. That's what makes the Palestinian case so unique as a refugee question because it is both a refugee question and a national question. And it is, of course, up to the individual to decide whether they wish to return or obtain compensation. But restitution of property and return are two separate rights. You can decide not to return, but you still are entitled to your property being restituted. And then you voluntarily decide what you want to do with that property. And that was embodied, by the way, in the Dayton Accord as well, where not a single penny was paid in compensation because the motivation was to reverse the ethnic cleansing, and therefore all property was restituted. Setting aside secondary occupant rights, we can talk about that separately. But that's why this is both a nationality, a national right, a collective right, as well as the right of an individual.
And of course, you see that the right of self-determination was absolutely embodied in the advisory opinion of the ICJ from 2004 and in 2024. So Haydee, I had a question for you as well, since I don't see any other questions in the hall. There's one, okay. We'll come down in a second. But I would like to ask you about another case that has been pending, still pending for the International Court of Justice, namely the matter that was brought by South Africa in relation to charges of genocide. To what extent can the argumentation that emerged within this ICJ case, there's quite a lot of testimony, legal argumentation which has been provided by the South African legal team. To what extent can that be applied? And can the provisional measures that the ICJ has already issued be applied in relation to the case that you are pursuing together with the law clinic at the ICC?
Yeah, it is a good question. I do want to respond to the one about individual versus collective rights quickly first, just to add on from the perspective of international criminal law that, while we're looking at an individual right, when we're analyzing it through the lens of international criminal law, and particularly crimes against humanity, there is that contextual requirement that the crimes are widespread or systematic. So it doesn't mean that every right violation that's analyzed needs to be identical, but there does need to be a pattern, a widespread demonstration that this violation is happening on a systematic way that shows a pattern. And so, it's still an individual right, but looked at it as a collective as well. On the question of the ICJ, it's a good question, and I'm happy to open it up to my colleagues as well, because I'm not sure if I have a completely thorough answer without taking a little bit of time to think about it. But it's different areas of law in the sense that international criminal law has a very distinct legal framework from what's being considered at the ICJ, but it still overlaps a lot because what's being analyzed there, when I talked about before those underlying acts, the same actions are being analyzed under a different body of law in the context of the crime of genocide and the Genocide Convention. And so what the ICJ determines, what evidence is submitted, the way that it's argued under that body of law, I think will have a lot of repercussions to what's also looked at this ICC as well. So something that we all need to follow closely in the same way that, if a case was brought before a UN or human rights mechanism under human rights law, it has an overlap as well, even though it's under another body of law. So certainly something to follow quite closely, and which I think potentially, because when we were talking about before all the different kinds of acts that could constitute a violation of the right to return, whether it's property damage or, Ahmed, as you were saying about when we're looking at the wider context of it, you also have to look at the destruction of schools and hospitals and everything that's making at the moment, Gaza, a place that's unlivable and is going to, in effect, result in an inability for individuals in that population to return home. Those are the kinds of acts that the ICJ is considering. So let's follow that and let's see the way that it's being presented and the decisions that are being made at the ICJ. I'll stop there on that one for now, but anyone else want to weigh in on that?
Yes, on the ICJ question, it's important to note that the court also talked about the responsibility of Israel to allow those who were displaced throughout the occupation to return to their house of residence. And here it's important, the connection, because we're talking primarily about how the occupation was determined to be unlawful because it constitutes a denial of the right to self-determination. So obviously there is a connection between the right to return and the right to self-determination, especially in the context of settler colonialism. And this goes back to the idea of nationality. And if we go from international criminal law perspective, there's always on what ground? Is it national ground, ethnic ground? So the right to self-determination plays a crucial role, especially in ICC proceedings. It's important to note when the court decided its jurisdiction, the judges had to mention that this is in accordance with the right to self-determination, because the applicable law of the ICC obliged the court to ensure that any ruling of the court must be consistent with the internationally recognized human rights. And on top of those is the right to self-determination in this situation in Palestine. And the court had already gave this reasoning and had to elaborate, saying, we decide there is jurisdiction and this is consistent with the right of the Palestinian people to self-determination. And this will, for me, the way I understand it, this is a test, and that the court will have to examine every step of the way, because Article 21, paragraph 3, referring to this, says that the application and interpretation of the Rome Statute must be consistent with the internationally recognized human rights. So every step of the way, everything the court does must be consistent with the right of the Palestinian people to self-determination, and this, of course, include the right to return. But it goes back to the idea I was referring to, having in mind the settler colonial framework helps the office of the prosecutor to situate these acts within the greater context. And as you referred, Haydee, that even two acts that are before the temporary jurisdiction of the court, not necessarily to use crimes before that date, but to provide an overview and explain the context in which these crimes and criminal conducts took place. Thank you.
Thank you very much. I mean, I know also as a former practitioner, evidence is everything, right? There's an abundance of evidence that has been gathered in relation to the ICJ case. There's been abundance of evidence that's been gathered also by organizations such as Al-Haq, such as PCHR, such as Adamir, such as Al-Mazan, and many other human rights organizations that have been continually interacting with the International Criminal Court since it first began receiving evidence in relation to the preliminary inquiries phase. So now moving from litigation to advocacy, because this is one of the questions which has been posed by Yosra El-Gendi. Litigation may be strengthened by advocacy. So there's often what's happening in the courtroom is very much related to what's happening in the streets and what's happening in many other places of legal mobilization. So for that very case being litigated for the right of return, how do you see the political advocacy proceeding, and what states would potentially support it at the present time? More specifically, how do you see the re-election of Trump and the impact of that? Pretty tough questions, but would anyone endeavor to answer that?
The two Americans.
Okay. I think the way that I want to address that is really just through the law. I mean, the way that my role, the way that I approach these kinds of questions, I think has to be through the law as a lawyer, and to keep the politics out of it. It's something that, you know, at ICJP, when collecting evidence or looking at any kind of legal steps, it's not for the purpose of politics, or, you know, politics shouldn't get involved in that, but it should really be based on looking at the facts and seeing where they lead and how that the law can be applied. And I think, you know, with everything that's happened in, you know, the last few months with global politics, the US included, there needs to be a recommitment to the rule of law and to just grounding ourselves in an international, you know, legal-based order and respect for international law. And I think it's something that's been chipped away at. You spoke before about France's reaction to the pretrial chamber granting those arrest warrants. You know, I think it's not only problematic and concerning for what it means for international law, but really comes right down to respect for international law. There's going to be many, many times that you know, it's a party or a person or an accused or a government that's not going to agree with what the court decides, but you have to follow it anyways. You need to respect the rule of law in order to invest ourselves in this project of international justice that sometimes you're not going to agree with it, sometimes you are, but it's about respecting it and preserving it for generations to come. So I really think I'm just going to lean on that we need to have a respect for the rule of law and resist the temptation to get pulled into the political aspects of this.
So I think my response might be a little bit different in the sense that I no longer see our work as lawyers in these highly charged arenas as being separate from the activism. And we've learned over the years, I've been involved in many cases against Israeli defendants and on behalf of Palestinians in the US. And we have been so far unsuccessful at holding a single Israeli perpetrator accountable through the US domestic legal system. And, you know, there's been a network that has been fighting on behalf of, for example, Arabs and Muslims since 9/11, and the Muslim ban. And the struggles have gone on from administration to administration, and it hasn't mattered whether it's been Republican or Democratic. The fights are very much, there's a pattern to who's vulnerable, who is entitled to justice and who is not. And that's true at the international arena. I'm sad to say it's true in our domestic arena. And so the protests that have been happening in the United States have been really a sea change in a lot of ways that may not be so visible to people outside. For example, for the very first time, we've had 19 senators vote to block aid to Israel. I never imagined seeing that in my lifetime. And that's because of the activism. That's not because of legal cases. So these can't be separated. We have to work more closely together with our activist partners and be more creative about the way we use our legal strategies in tandem with activists who are, you know, working towards the same objectives of justice as we are. And the fights are going to get worse, but I think justice is not an upward trajectory. It goes up and down. And I like to think, because I was engaged for so many years in the struggles in Central America, in Guatemala and El Salvador, and the civil wars there. And I saw how the work of the activists on the ground with the Inter-American Commission of Human Rights changed the landscape in so many ways. For example, across the Americas now, immunity laws are impossible. They're outlawed. And that is the result of struggle. We can do that, but we need to be smarter about our strategies, and we need to unite law and activism in a more powerful way than I think we've been successful thus far.
Very briefly, no, I totally agree. They go hand in hand, and I have to say that the way we've been doing our work at Al-Haq, it has been inspired by the movement of the people on the ground and previous experiences and historical examples of struggle against colonialism and apartheid. So this bottom-up approach, where we believe in and follow, it's because of people's opinions, and it cannot be. I think it cannot be clear now that what people want, which is translated in what you see in the streets, people demonstrating against their governments, protesting to stop the genocide, and what their governments are doing. The huge gap is just immense, and this really resonates to a certain point of history in the lifetime of the apartheid regime in South Africa. A lot of people tend to forget that it was people who mobilized on the ground. Governments were only latecomers. It was a similar situation. They did support South Africa. I will even tell you more. and it goes to what you say. It's actually a struggle results in really good precedent, good things that all humanity can benefit from. The struggle in South Africa resulted in the Apartheid Convention, right? And it was one of the first, if not the first, legal convention, a document where it referenced colonialism. And maybe perhaps this is the reason that until this very moment, maybe this comes as a surprise, but most European countries are not party to the Apartheid Convention and refuse to sign it until this very moment. It seems really strange. Like, who would be against apartheid? Who would be like against having a convention to criminalize apartheid? Most of European countries are not parties to it. Until this very moment, they refuse to sign it because of that reference to colonialism, amongst other things. And now that the prohibition of apartheid is actually, my view and many believe, is customary international law, not only because of the Apartheid Convention, it's actually embodied in the Rome Statute, which most of these states signed on. So apartheid here, but not there. Why? Again, the reference to colonialism, because these are countries that are very anxious about their shameful history of colonialism, genocide, and horrific crimes that have been committed against indigenous people across the world. And this has inspired our work at Al-Haq to have this bottom-up approach and get our strength from people in the streets in following these strategic litigation cases we take. And that's something I want to say also here, that the reason it's called a strategic litigation, that sometimes you win by losing. You don't take a case just to win. Sometimes you take a case even if you know you have no prospect of success. It depends on the strategy you're following. So we had several cases. The case in the US, I was there, I testified in this case against Biden, Blinken, and Austin for their complicity and their failure to prevent genocide. Our case in the UK, where the UK government, only 1.5 working hours before the deadline that they had, they issued the decision to suspend the 30 arms licenses, and they communicated it as 30 arms licenses to actually downplay what they did, because they didn't want to piss off their allies, but it was much more than that. And this was because of our case. I'll give you another example, which, by the way, we're still continuing at the moment. In Canada, the suspension of arms exports to Israel came after an advice from the parliament that is not, it's only advisory, it's not binding. And it was the first time, I think, that the Canadian government took this advice. This was also after a case we had in Canada, which is still ongoing. We like to believe it's because of our case. So you see, like, litigation and advocacy go hand in hand. And I have to say that this is something civil society need to think about a lot. We can't do advocacy as much as we want. Sometimes governments will just not listen. But when you sue them in their own legal systems, things might change. And at Al-Haq, we're very determined to hold every government responsible to account before their courts, before the legal system, but most importantly, before their people and before history. This is a record of history. We will not allow this just to pass and not be remembered. We will always remember that they have blood of Palestinian children on their hands, and they will always be remembered as complicit in this genocide. Thank you.
Thank you very much. And with these words, I hear the echoes of events that took place in this room before us, some events in which you have both participated in, but also a number of events in which our colleague, Professor John Dugard, has spoken on. He was indeed very much involved in the drafting of the Apartheid Convention, a very renowned South African law professor, also a Dutch law professor. He was at Leiden University, head chair of international law for some time. Great, I see a question in the back there. But I just want to sort of mention that because, yeah, when you've organized enough events, you begin to sort of hear these things come back. I also want to say that we can give a shout out to many different organizations. So the work you mentioned, the Center for Constitutional Rights, which together with Defense for Children International Palestine brought this case against the Biden administration. And although it was pretty clear that it was unlikely that it was going to go anywhere, it developed a tremendous amount of awareness around what was happening and the complicity of the Biden administration. There's also, of course, Jewish Voices for Peace, which have been tremendously active in amplifying what's happening in the courts as well. I can certainly appreciate what you're saying, Haydee, is that as lawyers, we need to be careful about not politicizing these cases. But clearly there's an important relationship between all of that. Thank you very much. I'm going to walk over here.
Okay. Oh, perfect. So I have a question about the second arrest warrant for Ahmed Abofoul that was issued by the ICC. Knowing the amount of fabricated evidence on social media and the creation of the website OTP link by the prosecution so people can submit their own evidence on this website, how can we be sure that the prosecution will not fall into the trap of false evidence fabricated by the Zionists to incriminate the Palestinian resistance like the 40 babies? Please. Thank you.
So there is this mechanism at the ICC. It's the Article 15 mechanism for any individual or group. It really opens the door for anyone to submit evidence to the prosecution, which might be helpful. Any information that falls within the jurisdiction of the court. It's therefore, after that, for the prosecution to thoroughly analyze it, not to take it on face value, but to look at what's been submitted, look into who's also submitting it, how it was collected as well. Remember, it's not just about what the evidence is, but also what was the chain of custody, how is it being preserved? Is it something that's credible? How will the judges weigh it? So that, there's an analysis that will be undertaken by the prosecution for any information that would be received. And I think that they do take that responsibility quite seriously.
I can. Yeah, thank you for this question. It's important to note that the ICC does not just receive information and issue arrest warrants based on that information they receive. I have to understand the professional investigators and lawyers. They verify the information they receive, and they conduct their own investigations. And I don't expect them to take something to court that they're not completely willing to defend. But it's important to note that in international criminal proceedings, it is not unlikely for prosecutors to take certain cases based on evidence at a certain stage that they will not be able to maintain at a later stage. What I mean here, for example, what is required for the issuing of arrest warrants is the burden of proof of reasonable grounds to believe, and it's rather a very low threshold. When there is a confirmation of charges, then we go to substantial grounds to believe, so it's a higher threshold once the person is in court, and once the judges decide whether to confirm the charges or not. And it happened in the context of the court that many charges were not confirmed or were modified depending on the situation. And then at a later stage, when you have the trial, the court will not issue a verdict before having the third and stricter burden of proof, let's say, the standards, which is beyond reasonable doubt that the crime took place. And it happened again in the context of the court that certain people went to trial and were acquitted after that. So this is a judicial process, and we have to trust it. And the Palestinian position has been very clear, including, it's worth mentioning, all Palestinian factions have agreed to comply with the International Criminal Court, including Hamas. Hamas has signed documents saying that they're willing to go to the International Criminal Court. And as civil society, we have been calling this for decades, and we call for justice as it should be. And since they agreed, they should go to court and defend themselves. And this is judicial process. The question is, we're at the situation where, quote unquote, as the West want to call certain Palestinian factions, terrorist organizations are agreeing to go to court, and quote unquote, the only democracy in the Middle East refuses to go to court. So I'm not sure who's the civilized here. Thank you.
If I could just add on to that quickly, because I think you brought up quite a few important points. Just to add on to that I think this is also where the right to a defense is very important as well. And remembering that this trial that might be upcoming, if you get past the confirmation of charges phase and after the prosecution presents its evidence, remaining very vigilant to the right to a fair trial, both for all parties. So for the defense, at the ICC, victims are parties as well, and the prosecution. Because as the prosecution is preparing its case, presenting an application for arrest warrant, looking at confirmation of charges, what they will be doing is knowing that eventually that evidence is going to get tested by the defense during cross-examination or the defense case, where they can also present alternative, their case as well, and their evidence the prosecution's evidence will be tested. And it's a really important process that evidence is thoroughly tested and analyzed, and to make sure that, in the very end, when there is a judgment, that it's based on the fact that all parties had a right to present their case, and that it's solidly grounded on that.
We got 2 more questions. Excuse me, we have 2 more questions. And I think that we should basically make these the last questions, and then we can wrap up. The first, which is specifically directed to Professor Akram, is, can it be said that prior to the 7th of October, Israel was already in a state of war against the Palestinians under international law, such as the blockade of Gaza, but also the settlements in the West Bank? So was there already a state of war? And then the other, yes, you got that. The other, which is from Albuquerque JVP, which I think is Jewish Voices for Peace, I just mentioned them. Thanks for this useful panel. She's part of an organizing committee for a new group, Global Solidarity for Peace in Palestine. And that talks a bit more about the organizations. They focus on various elements of the United Nations system. Could you give us advice on how to make our work more impactful and pressure points within the EU and UN legal mechanisms and our organizations or agencies or champions? I mean, I got a tip, which is through the Legal Mobilization Platform, but I'll leave that to my closing comments. Please, Susan.
So I'll just start with the first, and then please add on. Technically, before October 7th, Gaza was under occupation, as with all of the West Bank and East Jerusalem. And therefore, it's not a state of war in the same sense. It's an international armed conflict based on occupation law. And what has muddled the waters somewhat is the prosecutor's request that seems to indicate that both non-international and international armed conflict are being applied. I think that's erroneous. It's pretty clear that under the Fourth Geneva Convention, what belligerent occupation triggers, and it is an international armed conflict, and therefore the rules change somewhat in terms of the obligations of the occupier. And as the court said, the International Court of Justice said in the 2004 Wall opinion, that Israel does not have the right to self-defense against a territory and a people in a territory that it occupies. Anything else on that?
I agree. Okay, thank you very much. So I'm going to close by saying some thanks, obviously, to other organizations and individuals involved here. I do want to mention that at the Legal Mobilization Platform, the very reason why we established this space, which again, Ahmed Abofoul and Al-Haq was very much integral in helping establish, together with climate justice organizations such as Greenpeace and Milieu Defense and Stop Ecocide Foundation, who are also now very active at the International Criminal Court. I think actually Stop Ecocide Foundation had an event today, also on the crime of ecocide. So we're looking at climate justice, racial justice, and social and economic justice, and the ways in which academic work can be brought together with the work of practitioners doing the work of legal mobilization, also organizations like Albuquerque JVP. So we will reach out to you all and hope that you can become a member of our platform, which now has more than 300 individual members and more than 30 institutional partners. And we're establishing now, as of next year, various hubs within the Netherlands and other parts of the world to find a way in which we can kind of strengthen these conversations. And because it does, take more than just a village in these enormous cases. So I really want to extend my gratitude to, first of all, the panelists, Ahmed Abofoul, Susan Akram, and Haydee Dijkstal, excuse me. I also want to very much thank the organizations that sponsored this event, the International Center of Justice for Palestinians, Boston University School of Law, Human Rights Law Clinic, and of course, Al-Haq organization and Al-Haq Europe. Thank you very much for sharing your wisdom, your knowledge, your experience, long time working on these issues. And to you, those of you in the room and online, thank you also for sharing with us. Please do stay in touch with us through the platform. Again, this is why we established this community. And if you go to www.iss.nl/LMP, you can find information about how you can join as an individual member or as an institutional partner. Thank you very much. Go well. Take care. Goodbye.